everyone, I'm Christian Candelaria.
And I'm Anyssa Chong.
Today, we will be talking about the common provisions of the constitutional commissions, which can be found in the 1987 Philippine Constitution.
So, what are the constitutional commissions?
Section 1. The constitutional commissions, which shall be independent, are the Civil Service Commission, the Commission on Elections, and the Commission on Audit. Section 2. No member of a constitutional commission shall, during his tenure, hold any other office or employment. Neither shall he engage in the practice of any profession or in the active management or control of any business which, in any way, may be affected by the functions of his office, nor shall he be financially interested, directly or indirectly, in any contract with, or in any franchise or privilege granted by the government, any of its subdivisions, agencies, or instrumentalities, including government-owned or controlled corporations, or their subsidiaries.
Section 3. The salary of the chairman and the commissioners shall be fixed by law and shall not be decreased during their tenure. Section 4. The constitutional commissions shall appoint their officials and employees in accordance with law. Section 5. The Commission shall enjoy fiscal autonomy. Their approved annual appropriations shall be automatically and regularly released.
Section 5 of the General Provisions discusses the fiscal autonomy of the commissions. Their annual appropriations shall be automatically and regularly released. This provision subjects the commissions to three different rules. 1. That the annual appropriation shall be automatically and regularly released. 2. That they shall not be subject to pre-auditing. And 3. That they shall not be subject to the no report and no release policy. So, what other thing can we take out of this provision? That the Department of Budget Management may not retain any portion, nor may it program the release. So that's it. Enjoy fiscal autonomy for the commissions.
Section 6 talks about promulgating its own rules and procedures. So each commission and bank has the power to promulgate its own rules and procedures regarding pleadings and practices before it or any of its offices. Such rules shall not diminish substantive rights or increase it nor modify it. In cases of conflict, in court, the rules of court shall govern over the promulgated rules of each commission. However, before its offices, it's the rules of the commission that will govern. Statutes at all costs will always prevail over the promulgated rules by the commission. The Supreme Court has no power to disprove commission rules except in cases of judicial review. Congress also cannot assume the power to review the commission rules.
Section 7 of the General Provisions discusses the decision-making process of the constitutional commissions. So each commission shall decide by a majority vote of all its members any case or matter submitted within 60 days from submission for decision or resolution. So any case or matter is deemed submitted already when it's filed by a final pleading, brief, or memorandum required by its rules or by the commission itself. Any case decided by the commissions may be submitted to the Supreme Court within 30 days by the aggrieved party by certiorari. So, for better reference, one can look into Rule 65 of the Rules of Court. So, as an exception to these rules, the final executory and non-appealable decisions of the COMELEC and the COMELEC only may be filed to the Supreme Court for certiorari. So any case handled by the COMELEC which deals with the constitutional right to suffrage may be dwelled into the commissions as well as the Supreme Court for supervisory functions. So in a nutshell, these are the rules for the decision making of the constitutional commissions.
The last section of the common provisions is Section 8, which basically talks about the other functions of the constitutional commissions. It basically says that so long as Congress provides laws for it and that it is within the bounds of the Constitution, other functions can be added to it.
Wow, that's a lot of information, right, Anyssa?
I know, right, Mikey? But in order for us to have a better understanding of the law and the provisions, let's go on to Dean Mac.
Take it away, Dean Mac.
Good day, Mikey and Anyssa. This is Dean Mac at your service. Before we go straight to the meat of the general provisions, let's talk about Section 1 and Section 2 first. In Funa versus Chairman, the court upheld the independence of constitutional commissions. President Arroyo appointed Francisco Duque III as chairman of the Civil Service Commission. He was confirmed by the Commission on Appointments. President Arroyo then issued EO 864, which included the chairman of the CSC in the Board of Trustees of GSIS, PhilHealth, Employees Compensation Commission, and Home Development Mutual Fund. The court ruled in this case that the chairman of the CSC cannot be appointed as a trustee of these GOCCs because Duque's designation as member of the governing boards of the said GOCCs impairs the independence of the CSC, which was provided clearly in the provisions in Section 1 and Section 2 of Article 9. Fast track to Section 7, De La Llama versus COA chairperson tells us that decisions and orders of a commission reviewable by court are those under quasi-judicial capacity and not quasi-legislative or rule-making powers of commissions. During the Marcos regime, COA issued a circular lifting the system of pre-audit of government financial transactions. However, after the 1986 revolution, grave irregularities and anomalies in the government's financial transactions were revealed. COA then issued another circular reinstating the pre-audit of selected government transactions. But after the political heat has receded, COA lifted the pre-audit system once again. De La Llama alleges that the pre-audit duty of the COA cannot be lifted by a mere circular. But COA argued that in issuing the latest circular, it did not exercise quasi-judicial functions. In this case, the court ruled that De La Llama is correct in claiming that decisions and orders of the COA are reviewable by the court, but only those with quasi-judicial functions and not those circulars which are under rule-making powers of COA. So there you are, class. The case of Diocese of Bacolod versus COMELEC teaches us that fundamental rights are supreme over decisions of commissions. In this case, petitioners posted 2 tarpaulins within the compound of the church in Bacolod. Each was approximately 6 by 10 feet in size. It classified then candidates for re-election as either Team Patay or Team Buhay. COMELEC ordered the removal of such tarpaulins within 3 days from receipt of being oversized because the COMELEC Resolution number 9615 provides for the size requirement of 2 by 3 feet for election propaganda materials. The COMELEC contends that the assailed notice and letter are not subject for the court's review because it is limited only to final decisions, rulings, and orders of the COMELEC and bank rendered in the exercise of its adjudicatory or quasi-judicial powers. The court may review such decision because the main issue is the infringement on the constitutional right of freedom of expression and not the exercise of the COMELEC's quasi-judicial powers. The court also states that a breach of the fundamental right of expression by COMELEC is a grave abuse of discretion. Thus, the constitutionality of the notice and letter coming from COMELEC is within the court's power to review. So our next case is Fortune Life Insurance versus COA. The case tells us that any decision rendered by the Constitutional Commission should be filed to the Supreme Court within 30 days from the receipt of the decision. In this case, Commission on Audit or COA and Fortune
executed a memorandum of agreement on the life insurance coverage of qualified barangay secretaries, treasurers, and tanods with 4.3 million pesos for premium payment. They submitted a disbursement voucher to COA Antique for pre-audit. However, COA Antique disallowed the payment for lack of legal basis under the local government code. Petitioner filed to the Supreme Court the review for certiorari 31 days after receiving the decision of the COA. In this case, the court ruled that the petitioner failed to file the petition on time. A petition must be filed within 30 days from the notice of the judgment, final order, or resolution sought to be reviewed. Rules of Court provides that petitioner has 5 days from receipt of denial of motion for reconsideration to file the petition. Petitioner exceeded the time prescribed. So, no grave abuse of discretion on the part of COA because first, the delay of COA in rendering its decision was not arbitrary nor whimsical. Second, the briefness of a decision is not a factor demonstrating grave abuse. And third, in this case, Senator Pimentel expressing his opinion does not matter since the decision of the COA commissioners had value and decisiveness of the issues. Our last case for general provisions tells us that the court has consistently held that the phrase decision, order, or ruling of the constitutional commissions that may be brought to the Supreme Court is not all-encompassing. It only relates to those rendered in the Commission's exercise of quasi-judicial powers. In Kerubin, the COMELEC did not commit grave abuse of discretion when it approved Smartmatic JV as the bidder eligible for the lease with option to purchase of 23,000 units of optical scan system for the 2016 elections. The case does not stem from an election controversy but pertains to procurement process and its initial finding that Smartmatic JV is eligible to participate therein. The subject matter does not need the COMELEC's exercise of its quasi-judicial functions because it is actually administrative in nature. Alright, okay class, there you are. Back to you, Anyssa and Mikee.
That's it for today.
Thank you for listening. Hope that was very informative.
Again, I'm Christian Candelaria.
And I'm Anyssa Chong. See you next time.